This is Chapter 18, the Federal Court System. Discussion number 1, Terms of the Judiciary. As we're starting the federal judicial system, there's a lot of different terms that are not been part of your normal vocabulary. So we're going to spend this first discussion talking about a lot of the different terms that are involved with the federal court system. First of all, I want you to realize that we have a dual court system here in the United States. Every single state has their own court system with a set of laws that have been written up by each state that they're responsible for adjudicating. There is also a federal court system that deals with all the laws that the federal Congress has created and is being enforced by the executive branch. Sometimes you can commit one act and be guilty of both a federal crime and a state crime. Now, in the federal court system, and we're going to talk almost exclusively about the federal court system as we go through this unit. There are essentially two types of federal courts. First is the ones that are exercising the judicial power of the United States in the constitutional court. For example, district courts, Court of Appeals, and the Court of International Trade, and also the U.S. Supreme Court. But Congress has also created special courts to hear a very narrow set of types of cases. For example, Court of Appeals for the Armed Forces, Veterans Appeals, Claims Court, Tax Courts, U.S. Territorial Courts are all specially created to deal with a very specific problem or specific ideas within the federal government purvey. Now, one of the most important terms that you're going to hear when you deal with the court systems is the idea of jurisdiction. What authority does a court have to hear a particular case? For example, if a crime is committed in Pennsylvania, jurisdiction would be in Pennsylvania. You could not take your court case and say that you're going to be charged with a Illinois crime because that's not where the crime happened. Jurisdiction is based on where it happened. Now, like remember I said in the previous slide, it is possible to be in one act break a federal crime and a state crime. This is what is referred to as concurrent jurisdiction when both the state and federal courts can hear a case. Now, how do you end up in federal court? First of all, is there any question dealing with federal law or the U.S. Constitution? Is there any question of admiralty or maritime laws? This is dealing with the waters of oceans around the United States, and obviously since they don't belong to the states, they belong to the federal government. That's why it's a federal court jurisdiction issue. If an ambassador is being sued or being charged or anything like that, foreign or domestic, an ambassador goes to federal court, not to a state court. Also, if any particular state is being sued or is part of the actions, any constitutional limit says that the citizen cannot sue their own state without permission. It's a sovereign country. They get to decide what the suit's going to be. Now, another term you're going to hear is that of the litigants. These are the people who are actually involved in the case. The plaintiff is the litigant who is bringing the case to the court. If it's a criminal case, the plaintiff is more frequently referred to as the prosecution. They're the complaining person saying something went wrong, whether it be criminal case in the district attorney or you're suing someone because they broke blah, blah, blah. All right. The defense is always the person who's being charged with either a criminal malfeasance or a civil malfeasance. Some other terms you're going to run into is that of original jurisdiction and appellate jurisdiction. This is essentially what kind of event is going to happen in the courtroom. Original jurisdiction is what, when we think of courtrooms, this is what we usually think of. There's a jury, there's going to be a judge, a court reporter who's taking down all the information, attorneys, witnesses, evidence, verdicts. Those all happen in original jurisdiction where all the facts are heard of the case. Now, the appellate jurisdiction, there are no witnesses, there is no evidence presented. It is completely legal argument about whether the original jurisdiction court, whether they made a mistake or whether something was done incorrectly those types of things based on legal argument, precedent, and the Constitution, and whatever other argument is wanted to be presented by the attorneys. The district courts are all original jurisdiction. The Court of Appeals has mostly appellate jurisdiction. The U.S. Supreme Court is primarily appellate jurisdiction. There's a very few cases where the Supreme Court is considered original jurisdiction, and they're very few and far between, maybe 2 a year at most. So, United States cannot be sued without its consent. Remember that the United States, in its sovereignty, has complete power over what happens in its territory. That would include being sued and whether they actually want to listen to it. Based on the United States Constitution and based on the idea of the republic and democracy, the United States does have written into its laws that there are certain ways that the United States will allow itself to be sued by its citizens. The U.S. Congress has spelled these out in various ideas of legislation. And so if the U.S. is if the citizens are unhappy with the United States, they can seek redress. Whenever you sue someone in court, you are seeking redress. What does redress mean? That means you are saying, this is what I want for a solution. You give me money. The prosecution is seeking redress. I want that person in jail. Some other terms that you're going to run into, we have criminal case, where a law has been defined saying that a particular action is illegal, and that is punishable by imprisonment, by fines. Then they take them to court. They get a jury to say guilty. That is a criminal case. A civil case is a non-criminal matter where you're seeking for someone to make a decision for you, such as a contract dispute, legal ramifications, that type of idea. And so that is what is referred to as a civil case. Now, some other terms you're going to run into. First of all, let's talk about the term of office for a judge. First of all, a judge gets to be in their position because in the federal court system, remember, again, this whole thing's about the federal court system. The way that you get to be a federal court judge is that the president picks you to be a judge, and then you are also approved by the United States Senate. Then you are there for the rest of your life. There's no term of office for as far as 10 years, 4 years, whatever years you want to come up with. You can be there for the rest of your life, or you can retire. The only way you can be kicked out from being a judge is by Senate conviction, which means you had to be impeached by the House first. This has happened for very few judges, but that's the only way that you can remove them. Again, it's trying to make sure that judges are independent, who make justice decisions instead of popular decisions for the democracy. Also, judges cannot have their pay reduced while they are in office. Again, we don't want judges to think that they're going to be punished for unpopular decisions by having their pay decreased. Now, some other terms that we're going to deal with, or we can deal with when we're dealing with judges and their role in the courtroom, we can deal with judicial philosophy. And you're going to essentially hear two different ideas. There is the idea of judicial restraint and judicial activism. And while these can be very complicated with a lot of gray area type things, we're just going to kind of give it as straight to you as we can. Judicial restraint means that the judges believe that they are restrained specifically by what was the intent by the people who wrote the law, what was the intent by the people who actually wrote the Constitution. They also try to make sure that they do their best to follow the precedent of past cases. The idea of judicial activism means that these judges believe that they should rule in the best interests of the country, regardless of what the past has been. And sometimes they will go beyond legal precedents in order to create an idea that they think would be the better idea for the United States. There's no official way that this has to go. It is individual opinion and how you do that, but those are two big ideas of the judicial system. Now, how do they have the right to even overrule Congress law? Well, remember that Marbury v. Madison, the very important case near the beginning of the history of the United States, the Supreme Court claimed the power to say that Congress can do something unconstitutional. The President can do something unconstitutional. And so that power in itself creates judicial review where the Supreme Court can rule other branches of the government to be unconstitutional in their actions. This concludes discussion number 1, terms of the judiciary.